Greetings, everyone. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. And as you see, the streamer here says, truth needs no defense. It takes discernment. So we're going to talk about a little discernment tonight as it relates to abeyance. I don't know if any of you people are familiar with what abeyance is, so we're going to talk about that. And let's see here. We have my Wyrd Wyzard email down there. There's fair use, limitation of exclusive rights, fair use for free education review only, not monetized, and PayPal is for donations only. So let's get into it. And I want to ask you real quick here, brother, are you familiar with abeyance yourself?
No, I am not. This is the first time I heard that term.
Okay. Well, what we're looking at here, guys, is Samuel Johnson's dictionary. And this comes from 1773, 1775, or 1755. It comes from from French, and this is saying the same thing over here that it says in the actual microfilm or whatever they've got here, the digital. It says abeyance, N.S. I'm not sure what that means here, so we're going to look into that deeper sometime. But for now, just know it's from the French aboyer, alatraire, to bark. You know, this is nothing but a big circus where you got a bunch of snake oil salesmen barking their wares. This word in Littleton Cap discontinuance is thus used. The right of fee simple lieth in abeyance, when it is all only in remembrance, intendment, and consideration of the law. The frank tenement, this being frank, the first tenement of the glebe, which is the soil, the globe, the glob, the handful of dirt that was exchanged when you exchanged land. Of the parsonage and not the personage, is in no man during the time that the parsonage is void, but is in abeyance. In other words, if you don't know how to fill the void of the parsonage, and that's the clergyman or the chaplain, the minister, the one that's supposed to prophet the word of God unto the nations, until you recognize that parsonage is void. Okay? But that estate is held in abeyance. This is the good faith intent of full faith and credit, where again the merits is defined as the spiritual credence, the spiritual credit. And that's what you need to fill that void in the parsonage with, is the spiritual credence. The only way you can do that is by giving all glory to God, all glory to Him. One of those things that you do to prevent the estate from being put in abeyance is you hark the herald angels sing. And as the song goes, glory be to the newborn king. I'm not saying glory be to the newborn king. I don't agree with that, because like I said, all glory goes to God, all glory goes to Him. But it would be much better phrased as blessed be the newborn king. And so therefore what we're supposed to do when that baby is born, we're supposed to bless the newborn king. And this is what prevents my people are destroyed from lack of knowledge. Because in blessing the newborn king, you're not blessing with anything but that which God blesses, which is the providence of grace, the providence of His favor. And that's where you don't undertake, and understand that term, undertake. What's an undertake do? He takes care of the affairs of the dead. This is literally what people are doing. This is the spells being cast under the born in a spell of illness. 42 USC 1395X. That's where the estate is put in abeyance because of that creation of that documentation. And that abeyance is a military holding. Okay? That's why they create a legal estate, a company. The military has Company A, Company B, Company C. That's your alphabet company, guys. It's military in all venues. What do you think about that? Does that make sense?
It does, and it makes me want to get out of that system even more.
Well, and this is one of those things where I've expressed before, when you realize Jacob's ladder and how to demand your birthright. See, the names of Jacob's sons is how is spelling out your demand for birthright. And so sometime I might do another review on that. Otherwise, it should be in a playlist. There's 4 of them in there. Jacob's ladder is the first one, I think. And so when you realize how to demand your birthright, it's removing that stuff from being held in abeyance, and it's called the recovery of the estate. Again, this is held through the Social Security Administration's application where they create the estate. But when we look at that chart, the state's vital statistics jurisdiction that they create, that's for the health and human services. That's where the estate is created and held. And that's what you deal with the estate recovery. Every state's got to have a state recovery program, and it's managed through health and human services. And it's the legal estate that's held in abeyance. And again, you're born in a military hospital known as a foundling hospital, where they supposedly, as a military, during the course of war, found barren women and desolate children. Isaiah 54. And they're getting all the praise by singing this song out when you're supposed to. You're supposed to herald the hark the herald angels sing. You're supposed to be doing the singing, and you're supposed to be heralding and blessing a newborn king, a legacy heir of that throne on the right hand of God. Pure and simple. We were born prophets unto the nations, and that's the duty we're supposed to do, and not a one of us are doing that. We're signing documents of nationalities being conferred to us, of a United States citizen, and that United States citizen is not a nationality. It's listed in their very own codes as a corporation. Again, a military company. So let's take a look at the next one. And again, this is from Investopedia. Again, a military operation is an investment where you put on the armor of a nation because you don't have the faith of David fighting Goliath. Abeyance order. It's an order. What's an order? It's a draft. You know about the military draft? Oh, I'm sure you do. But until there's a draft, you're all volunteering. And even if it's a draft, you still have to have a capacity of being actually born in the military where mom and dad intended you to be brought up in that style. What it is, how it works. Example. What is an abeyance order? An abeyance order is a court order. Again, if he knew you before he formed you in the belly, and before you were cast from the womb, he sanctified you and ordained you. Do you see the similarity there? He put things in order. He ordained you a prophet unto the nations, and that is the word he wrote on your heart with the index finger of his right hand. That's how you are ordered. Declaring, and not clarifying, but declaring that the legal right to property or claim is held in abeyance. The legal right, which is legal title. So they're holding legal title, and it's admittance that they're holding legal title to property or claim in abeyance. In other words, they're admitting that it's not their property, or temporarily placed on hold until matters are resolved. Abeyance places the right to a property, title, or office in a state of expectancy. Mom, were you expectant when you were filling out that prenatal chart? Is that what was at the beginning of the charter and the maiden voyage, in which the claim is not vested to anyone, but is awaiting the determination of the true owner. Equity regards the beneficiary as the true owner. So now we see a court order declaring that the legal right to property or claim is held in abeyance or temporarily placed on hold until matters are resolved is a matter of trust. Are you comprehending the language? In advertising, as in adversity, an abeyance order refers to an order from an advertiser for a media slot on television or radio that is temporarily unavailable. As a result, the order may be held in abeyance until a suitable advertising slot opens up. So, what happens, folks, is that we have those identifications that are in a simple form of advertisement. It is known as the minimum requirements for a listing agreement. If you know your maritime codes, what is to list? It means to be out of balance and tilt to one side or the other, and thus there is a list. So a listing agreement is an agreement to be out of balance, and this is proven because every time you sign a document, it creates a debt. Meaning that it is not balanced, it is not zeroed out. And therefore, it needs a creditor to come forth and bail them out. Do you understand the language, people? Okay, let's go back to it. Key takeaways: property is held in abeyance until the true owner is determined. And again, the courts will deny the beneficiary being heard until he knows how to come up and show that he is the true owner. He must take the property in receipt and have it in his own holding. And now as holder, in due course, again a maritime term, steady forward, straight ahead, aye aye, Captain. Abeyance orders are used when parties agree to temporarily settle litigation. Again, it's a settlement, and why do you think they called them settlers? Because they came over and grabbed up a handful of soil, and that was their temporary settlement. They're trying to make it permanent. Abeyance orders are also common in bankruptcy proceedings because one party or another has to be able to have a handful of soil in these certain situations, such as common law. Jus soli, jus sanguinis, of the soil and of the blood. How an abeyance order works. Abeyance orders are used in cases where parties are interested in temporarily settling litigation while still holding the right to seek relief later if necessary. This allows an organization to settle with the party without officially binding its actions in the future. It is technically just like enforcing a contract, but clarifying that you are outside of the contract because you are not officially bound yet. Through the correction of the records, you will find it is impossible to bind you to office, particularly if you're following the laws of the Hebrew 6 verse 17, whereupon you undertake that oath, or assume that oath, or presume that oath, or take that oath, or accept that oath. However you want to word that, that is the clarification that pretty much helps nullify the rest of it. Abeyance orders are most often used in bankruptcy proceedings where the court declares that a claim on a property is held in abeyance because the rightful owner of a property or mortgage holder is not known, or the court has still to decide whether the property belongs to the creditors or heirs. Does that make sense? Remember, who created the document? Wouldn't that go to her credit? Wouldn't she be a co-creditor? So the creditors in that sense would truly be, and of course, the liable parties for claiming that the heir is somehow indebted to the creditor. If the creditor loves that heir and he professes that they owe no man anything but to love that heir, goodness gracious. See, this is where a trust shall not fail for want of trustee. Again, the simple gift is that of love, and the true benefit of it is the knowledge behind it. That knowledge is learning how to pass on the benefit without taking on a fictional liability. So let's continue on. Unless you got something to say here, brother. Like I say, feel free to chime in anytime.
You said it was Hebrews 6?
Verse 17.
I'm actually taking notes.
Okay. We continue on, and it says, this situation became common when foreclosures soared after the U.S. housing market collapsed in 2008. In those jurisdictions that followed the lien theory of mortgages, mortgagees do not have title to the property of a delinquent debtor until an order of foreclosure is granted by a court. So again, you see, as a mortgagee, they do not have title, or whoever the mortgagee is. Let's take a look real quick just to make sure we pass this on right as well. Mortgagee is the lender, right? So as long as they admit that they're the lender, then what's actually happening is that they don't have title. So you have to ask who has title. And this is why I keep telling you, So I keep telling you that title is held by who? The county registrar. If the county registrar is holding the title, then they must be the trustee that's supposed to pass it on to the beneficiary. So now all we have to do is identify who the true beneficiary is. Okay? And if they do not have title to the property of a delinquent debtor, then that's telling you they're not the delinquent debtor. It's somebody else, and they don't have title to the property. So why are they coming in and making claim to the property? Okay? They don't have any interest in the title. Oh, is that it? Is that what all that interest is in, guys? Who's claiming that interest, and how much interest is it they've got? See, if the bank is making the claim on the interest, is the interest the whole loan? And if you're paying off that loan and come to find out you had that loan for 10 years for $80,000, and in 10 years you paid $120,000, and you still got $60,000 to pay on it, and the bank's claiming interest, really? Really? Does that math really add up, folks? You really got to start thinking about this stuff. To the property of a delinquent debtor. How is it they're determined to be a delinquent debtor? Until an order of foreclosure is granted by a court, then they have title. That's when the title transfers. But does it really transfer to the bank? Or does it just transfer the interest in the title again? Other situations where abeyance orders are used include shipwrecks, where it is still to be determined who has the right to salvage a ship and its cargo. If you guys remember, not too long ago, I spoke about salvage rights. And again, this is the right to salvage your birthright and make the proper claim on your birthright. It's a salvation for all of the defamation. And again, you've been part of it. That's your part in resurrection, is you've got to recognize that parsonage, that freehold, that fee simple. There's not really a whole lot to it except to recognize your journey, your Jacob's ladder, and how to demand your birthright. That's Steve spoke about it earlier on Paul's panel, rebutting those 12 presumptions. I found that on my site, so I'm gonna have to go over that sometime. But also, I'm gonna have to rewrite it because I've come up with a lot of verses since 5 years ago that I can kind of simplify it, and it's going to be restructured. So I'll do a video on it the way it is, and then I'll redo it and show a video on it on the conversion or retransliteration, however you want to call it. But in the meantime, abeyance order example. One common scenario in which abeyance orders are used is in the English peerage, when a peerage title cannot be passed down due to lack of a legitimate claimant. If you're a foundling at that hospital, that's where they lack a legitimate claimant because nobody made the claim to begin with. So again, I'm posing that that's where you make that legitimate claim so the title can be passed appropriately. Most English peerage titles are passed only to sons, but some can be passed to a daughter if she is an only child or if her siblings have died without producing heirs. So let's look at that term peerage. This is the community that you're raised in. It takes a village to raise a child. The village, the community, is a community of your peers, each of them having their own children and their own families, familial structures. But as a peerage, that goes to that first and second name. As you're home with your family, you use the private name. That would probably most likely be the second name. Whereas your most popular name would be the first name, because that's where you go out into the populace in the popularity contest. I hope that helps explain that. If there are multiple female heirs, the title will go into abeyance until one person represents the claims of all the female heirs. This is where the father's lineage is needed to patch the maiden voyage, which is the inheritance and the legacy from which it comes. That way, whichever female heir that makes that claim on behalf of all the rest of the female heirs now has a son, and she too can pass on that legacy. It's just a story. So all she has to do is find another man that has the similar traits of her very own father in legacy. This is that parsonage, the spiritual aspect. Some English peerage titles have gone into abeyance for hundreds of years in this manner. I profess many more. The barony of Grey of Condor was in abeyance for more than 490 years, from 1496 until 1989, when the claim was called out of abeyance to favor the claim of Cornwall Lee family. 490 years. They must have been able to track that lineage down, huh? An abeyance order can also be used to settle litigation on a temporary basis for a life term estate. In other words, for the life estate, for as long as you live. And so long as you pass that knowledge on to your legacy heirs, they too shall be able to hark the herald angel and bless their newborn kings and keep that private estate private by, again, simply by passing on the knowledge. While still leaving the parties the right to resume litigation later if need be. And again, this is the importance of the life estate, because if they violate that private trust, that's what we're doing here, is setting up the private trust, and the enforcement of it is that that estate that they can't administrate, like I said earlier, in a probate of wills of a decedent. Because again, that's Scott versus McNeil. A court of probate has no jurisdiction over the estate of a person who is in fact alive. Organizations with a changeable political perspective or membership may use abeyance in this matter to settle a matter without committing to a future course of action. Okay? You don't commit, you don't bind your word to the future. You live in the now. For example, a Canadian lawsuit involving the University of Victoria Student Society and a campus pro-life club was put into abeyance, with UVSS agreeing to temporarily restore the funding it had previously withheld. In this manner, the pro-life club enjoyed a favorable outcome of the UVSS, avoided the costs of a lawsuit. Avoided the cost of a lawsuit. I mentioned this here recently as a matter of helping sustain the state and federal budget as it relates to the general ledger, while both parties retained the right to go back to court in the future, again, if need be. But again, part of this is recognizing that at some point your own status doesn't allow you in those administrative courts, which are, again, courts of probates of wills of decedent persons. Those are corporate fictions. And unless you are organized under the laws of the United States with a board of directors that can then hire an attorney to make a representation in those administrative courts, then you are not qualified. It is an impossibility. You remain at common law, and your remedy is in equity. Equity regards the beneficiary as the true owner. You are not a trustee of an administration in any capacity, unless you truly are. Anything on that, brother?
Um, I'll ask at the end of the at the end.
All right. Then let's look at the next one, because the next definition of abeyance, we've had two. One from Johnson's, what is it? Samuel Johnson's dictionary, and then Investopedia. Now we're going to look at Legal Information Institute. This is Cornell, Wex, abeyance. And they too agree with an abeyance is a temporary suspension of activity while awaiting the resolution of some other proceeding, without which the activity in abeyance cannot continue. In other words, when you question that personal jurisdiction and they fail to prove it, then the matters are technically supposed to be put in abeyance until that determination is resolved. Okay? In other words, what you're doing is putting the personal jurisdiction attack in abeyance until they prove that they can attack it. Okay? If you prove that personal identification is not something that they can attack because it's their own damn record, the individual's name and number identify the record. I don't hold any of your records. Sorry. See, that identification is the problem. You're holding it, and you're the rightful owner of the estate, but you're using it as a trustee. In the case of a plea in abeyance, the defendant enters a conditional plea of guilty, which is then held in abeyance subject to a set of conditions. I did this in my last case. Go ahead, brother.
Just to point out that when you're reading, you're not. There you go.
Got it.
I wanted to point out.
Got it. So abeyance from LII Wex, Legal Information Institute. In the case of a plea in abeyance, the defendant enters a conditional plea of guilty, which is then held in abeyance, subject to a set of conditions. One of the conditions I placed in my plea of guilt, upon the condition that the state recognize the individual's name and number identify the record. I was subsequently found, what was it? They say failure to appear, even though I stated it on and for their record in front of a stenographer, and my companion filmed it or videoed it. If the defendant fulfills these conditions, the charges are dropped. So they're the ones that came and attacked the person, and they're the ones that have to prove that the person is organized and with a board of directors and can hire an attorney for a objectionable defense. Does that make sense, brother?
Slightly.
So, if you're on the battlefield, and that battlefield happens to be a football field, and you think you can play football, but they don't supply you with the knee pads and all of that. Are you qualified to play the game? See, this is a third-party officious intermeddler that is to be provided for certain entities. Those certain entities are corporate entities that are known to be fictions and must be represented. And therefore, they must be provided, and this is why I said earlier, the providence of grace. He is the one that provides us with favor, but what they are provided with is a privilege to be represented by a bar attorney. I don't take upon that privilege. I seek counsel in our Father which art in heaven. Not only do I not take upon that privilege, I can't, because I seek counsel in our Father which art in heaven. And again, I'll let you know that a trust shall not fail for want of trustee. So when we involve one of these third-party officious intermeddlers that are acting as trustees, we can technically, by law, in law, at law, dismiss them for said malfeasance of trust. Because again, if they're the ones holding an official license or identification or certification, they're the ones that are so licensed by that granting authority, and they would be in violation of that grant. Romans 13, 1 through 8, folks. See, these people are subject to those courts, not you. So it's when we read Romans 13, where there is no power but that which is ordained of God, you have to let them know, again, Jeremiah 1:5, I was born a prophet unto the nations, so sanctified and ordained by God. That is the power invested in me, both faith and credit through the spiritual merit, or through the merits, which are the spiritual creeds. All glory goes to him. I am only the pass-through that ministers his word. If you haven't heard those words, then I imagine that you're going to be one of the ones that flees when no one follows. Because your time is going to come and he'll weigh your heart. I can't wait till my day comes. I'm not going to run. I'm not going to flee. I'm not even going to chase you. Because you're, again, going to be the ones that are going to flee where none follow. When you realize that, and a simple example is when this medical society got together, the medical associates around here tried telling my companion that they were going to discontinue providing her services, which is her benefit, if she didn't pay the bill, which insurance is a prepayment. And if you don't receive the benefit, then that's a violation of the contract. So they were threatening my companion the benefit of the insurance that's already paid through the state. She worked for the government all of her life. Okay? She's got an IPERS account and everything. And they're trying to tell her that she's not the beneficiary and that she's got to take upon a liability when that's not true. She's not only a protected American, but that person is now known as an international person and is protected internationally as well. And that's a simple term known as retirement. It's already in on and for the record that she's retired from any office and cannot fulfill the functions of public office, even though it may seem similar. And I've been trying to convince her and help her understand that anybody that comes to that door trying to tell her that she's qualified for this benefit, then she ought to accept the benefit without having to sign for it. Just tell them we'll make it so. You're the one that testified that I'm qualified for this benefit. Now you help me figure it out. You gave me notice and knowledge that I have a benefit. And now you're telling me I have to take on a liability of signing. I'm going to hold your ass liable. I want to know who your supervisor is. And they don't like it when I talk to them like that. So then we turn around, we call up Social Security Administration and ask them about that benefit. And lo and behold, yep. So we don't need to sign anything? No. Same thing with this medical associate. And they tried saying that she wasn't going to get her benefit unless she paid this bill. So I wrote them a nice letter and said, okay, as her trusted companion in life and liable and responsible for her and her safety and her well-being, I have to make sure, he who hateth suretyship is sure, I have to make sure that everything is true and correct. Could you please send me a true bill? So they sent me this nonsensical, impossible, supposed mathematical equation with not one plus sign, a couple minus signs here and there, but no total of anything that could be comprehended, no dollar sign, no nothing. So I literally told them that. It was incomprehensible, and I accepted it for the zero value that's presented in the document. You find me a mathematician that can figure that out, any accountant that can figure that out, when there's no two sides of the ledger there, you got to be able to determine if that came from the credit side or the debit side. Ain't none of that there. No dollar sign, no mention of dollars, no nothing. Just a bunch of numbers. Some have minuses, some don't. You expect me to figure it out for you? You're the one making the claim. Prove it. I see zero value. Show me the value. There's no value. That's been 2.5 years. She still gets everything she's required. A lot of this stuff, folks, like I said, what is done is what ought to be done. There is nothing new under the sun. You just have to learn what's being done. It's a usufruct system. Everything you possess in use is supposedly done by a claim of title. No, it's done by a claim of use. It's proper use. So let's see. If the defendant fills out or fulfills these conditions, the charges are dropped. Who dropped them? Who picked them up? Okay, where did they start? If the defendant fails to complete the conditions, the guilty plea is entered. For example, the defendant may be required to undergo a drug addiction treatment program or have a guilty plea entered. This is why I say, ask him if there's a term of probation. I'll plead guilty if the state admits that it could be accepted as a term of probation, and then expand upon that term of probation with Scott versus McNeil, that a court of probate has no jurisdiction over the estate of a person who is in fact alive. Shove it right down their throat. I'm not telling you to do that, but that's what I would do because I can stand on it. Every time they want to squiggle out of it, I'm going to show them where they're wrong, and I'm going to shove that same case law that they try to use against them. All real and personal effects encompass the entire estate. All real and personal effects. That means all tangible and intangible effects. So if I went out and acquired a bike, that would be an effect of my real actions. If it was a intangible effect, it would be because I started intangible thinking I need a bike. So it is both an intangible and real effect. All property of the estate is real and personal effects. Appeals can also be held in abeyance, usually to await the outcome of another court case which concerns similar issues. This is where we talk about the functions of public office, because that's the presumption all the way through, is that everybody's performing the functions of public office because they are acting similarly and filing and recording and doing all the paperwork known as a battle of the forms, and therefore an officer in a military investment. In property law, abeyance occurs when the true owner of property cannot immediately be determined. In property law, abeyance occurs when the true owner of property cannot be immediately be determined. So again, the claim there is the owner, the true owner of the property being held in abeyance, which is the legal estate established upon the certificate of live birth that mom filled out as informant and then was lodged into the birth records by the birth clerk, the enumeration at birth. That's that state's vital statistics jurisdiction that was created when you were born. That's the true founding document that doesn't have a statement of financial intent. So it's a legal estate that's been put in probate of wills because there is no will, there's no statement of intent. So once the will is stated, now it has to be recognized, and you have to be able to express it in trust. I fear not, for I have been redeemed. He has called me by thy name. I am his. I am his property. He uses me. I am for his possession and use. The living soul is the one that guides this property here. It is held in abeyance for the living soul to use while he's here. I am in his holding. As we continue on, the next one is real property. Remember, I said all real and personal effects encompass the entire estate. Real property, land law. Okay? Remember, we're talking about not the statutory codes and federal regulations and stuff, but the common law. Again, common law is the law of the land. Just soli and just sanguinis, born of the land and of the blood. The blood still flows through me. I am not a decedent. Property signifies dominion or right of use, control, and disposition. Disposition always, which one may lawfully exercise over things, objects, or land. One of the basic dividing lines between property is that between real property and personal property. Okay? Real property, like it says, land law. That comes from things of the land. So it would be even things like they call commodities, but that is not law of the land. That is more the personal property by nouns, where they get to name things as commodities. Whereas if your land law is merely the possession and use of the things provided, it would be all of the herbs, no matter how you wanted to describe them as nouns. Okay? Anything they want to describe as a commodity, such as corn or grain or flour or rice, you get to use as real property. Property signifies dominion or right of use, control, and disposition which one may lawfully exercise over things, objects, or land. This is the dominion. Okay, one of the basic dividing lines between property is that between real property and personal property, like I said, one is real, one is intangible. It's your thoughts. So your personal thoughts is what's going to control what you actually have in possession and use. Learn how to use it. This is your character development. Like I said, I've got 18 different channels for a reason. Each one of them's a different personality. It's personal property. Generally, the term real property refers to land. Land, in its general usage, includes not only the face of the earth, but everything of a permanent nature over or under it. As above, so below. And if you are on the land, you control that air above you and the land below you. This includes structures and minerals. There are further divisions within the real property classification. The most important are freehold estates, non-freehold estates, and concurrent estates. Others are future interests. See, this is why we've got to get rid of that future interest and make them life term or life estates, which are temporary, through irrevocable trusts, which are eternal, and you pass on the life estate. That's the inheritance. Specialty estates and incorporeal interests. Incorporeal interests. Freehold estates are those in which an individual has ownership for an indefinite period of time. An example of freehold estate is the fee simple absolute. The fee simple absolute, the right of fee simple absolutely lieth in abeyance. Because if you are not absolute, if you have not gone through absolution, then maybe there's a problem. Which is inheritable and lasts as long as the individual and his heirs wants to keep it. Another example is the life estate, what I've been talking about. The life estate is, in fee simple, absolute. You are granted the life of a man with a spiritual guidance. That is the providence of grace. That is the estate, is your life. Just soli, just sanguinis, the breath of life. And when he breathed that breath of life into you, that man became a living soul. It attained its spiritual guide. It was given the credence of being sanctified and ordained a prophet unto the nations, and nobody blessed the poor little child as a newborn king, so that people would be able to see him in all of the glory of God and hear the message that he spreads, the glory of God, in which the individual retains possession of the land for the duration of his or her life. People, Leviticus 25, verse 23 through 25 speaks about the land shall not be sold forever, for it is mine, and ye are strangers and sojourners with me. In all of the lands of your possession ye shall grant a redemption to the land. And if your brother be waxen and poor and have sold off his estate, and one of his kin come along to buy back that estate, his kin shall redeem him as well. It's a very simple resolution that's already given. It's a matter of being able to understand it, and it doesn't take just the one verse. You have to learn that scripture for what it's meant to, and that's being able to read behind the lines, read between the letters, read between the words, and understand that parable really means just an example. And like I said, a definition is just another man's opinion, and of course, it too is based on the examples of his experiences in life. So it's a matter of being able to discern your experiences as an example and try to correlate them to other examples that have proven better effects. If you already know that if you get caught in a lie, it might ruin your value, then why would you lie? You already know there's a better effect by telling the truth. This is why I say truth needs no defense. It takes discernment. Once you can discern the truth and sort out the lies, all you have to do is express the truth, and people are going to sit there and go, It might be hard at first, my family disowned me, but, there are going to be the people that are going to have the eyes to see and the ears to hear, and those are the ones you really need anyway. Those are the chosen ones. The ones that don't are following their own will. They have that free will. You have free will or a choice. And that's literally your choice. Follow your free will or somehow find a semblance in a greater will for a greater benefit for the greater of all, and quit being so selfish. So let's get on. Non-freehold estates are property interests of limited duration. That's all these bonds and stuff that are limited to, say, 90 days or a year or 3 years or 10 years or 30 years. They have limitations. Those are non-freehold estates. What's non-freehold? It means somebody had to pay for a title and license. They include tenancy for years, tenancy at will, and tenancy at sufferance. So, see, you're a lieutenant. You're a tenant in suffrage. You're a tenancy at sufferance, tenancy at will, tenancy for years in lieu of the true surety. That's the best thing I can call it, surety. So when you claim to be a tenant on a rental agreement, you're claiming to be the surety, okay? You're a lieutenant. You're a tenant in lieu of the original surety. You amended the surety contract. You amended the insurance policy. Concurrent estates exist when property is owned or possessed by two or more individuals simultaneously. Concurrent estates exist when property is owned or possessed by two or more individuals simultaneously. So if I hold the intangible property, the intellect that connects the real property in all situations, do I have a concurrent estate in that legal estate? Is that legal estate a concurrent estate with my private estate? Do I have a claim on that? Most certainly. For the most part, states have exclusive jurisdiction over the land within their borders, and their law concerning the kind of interest that can be held and how they are created is not subject to federal law. See real estate transactions. Real estate transactions. You're going to be surprised one day when I show you 7 U.S.C. 1922. We're not going to talk about that today, but one of these days. The next one, '31 U.S. Code 5312, definitions and application. Financial agency means a person acting for a person, except for a country, a monetary or financial authority acting as a monetary or financial authority, or an international financial institution of which the United States government is a member. As a financial institution, bailee, depository, trustee, or agent. See that license? That state identification that proves you're a resident agent for the state of Iowa. Or acting in a similar way. Acting in a similar way. All you have to do is act in a similar way, and you can be presumed through a legal fiction to be performing the functions of public office. Related to money, credit, securities, gold, a transaction in money, credit, securities, or gold, or a service provided with respect to money, securities, futures, precious metals, stones, and jewels, or value that substitutes for currency. Remember 18 U.S.C. 8 and how it discusses stamps and other representatives of value, or value that substitutes for currency. Are merits a specific type of value? The next one I want to look at is 26 U.S.C. 1014. Basis of property acquired from a decedent. And remember, folks, that's the enumeration at birth that creates the decedent estate, which is under 31 U.S.C. 1321, wherein they talk about trust funds, subsection 73, estates of decedents, comma, Department of State, that's the Secretary of State, of the Department of State, of the state of Iowa, Bureau of Vital Statistics, enumeration at birth that was created when I was born. And that's a trust fund, establishing a burial trust in case I passed away before I was age of majority. That's the state's estate that they created in trust. And they did so on the basis of property acquired from a decedent. B. Property acquired from the decedent for purposes of subsection A, the following property, and I'll remind you this is Title 26, the tax code. Okay? For purposes of subsection A, the following property shall be considered to have been acquired from or to have passed from the decedent. Property acquired by bequest, device, or inheritance, or by the decedent's estate from the decedent. 2. The important part here. Property transferred by the decedent during his lifetime in trust to pay the income for life to or on the order or direction of the decedent. This is telling us that it's the decedent that's supposed to order or direct things. But it's because it's held in a probate of wills of decedent administrative capacity, the administrator is making the orders and directives. With the right reserved to the decedent at all times before his death to revoke the trust. So again, Scott versus McNeil, a court of probate of wills of decedents cannot administrate the estate of a person who is in fact alive. It is done and established through enumeration at birth, through the exchange, another tax code known as a 1031 exchange. This exchange happens at enumeration at birth, wherein there's an exchange of a general journal for a general ledger, the birth clerk. 26 U.S. Code 1031, exchange of real property held for productive use or investment. Okay. Remember the claim of a state resident while being a United States citizen proves that you're a stateless being. So the claim of state resident is not a valid claim if you have a proper estate and want to state that estate. Under subsection H, it tells us real property located in the United States and real property located outside the United States are not property of like kind. I want to ask you guys, is your county in the United States? If the United States is located in Washington, D.C. Does that create some kind of inconsistency somewhere? Some kind of logical fallacy in the explanation that you were born in the United States? If you were in fact born in or at a certain place, a county, a location, where the location of the United States is in Washington, D.C. So again, the inconsistency is, how can you be born in the United States if you were born there and the United States is over there? Is the county in the United States? And if it is, in what form? It certainly wouldn't be the physical geographical county that would be located in the physical geographic boundaries of Washington, D.C., as that would be physically impossible. They are separately known geographically. So again, it asks you, were you born in the county? No, you couldn't have been born in the county. The county is merely a place where records are kept. It's the name and title of a record system. The county, as they describe by borders. Do you see the border? How could a man physically go out on that geographical map and or out on that geographical area without a map or any tools or anything and define what is Black Hawk County? You couldn't. It would have to be a specialization. Well, what's the specialization about it? It's the particulars of the language and everything. And until you get, again, unlearn the idiocy you've been taught to remember and relearn things such as the concise English and the interpretation of the scriptures in a positive light to show you how to get through this stuff. I'm telling you, folks, the scripture is key in everything. Again, like I said earlier, we discussed the 12 presumptions of the court earlier on Paul's. So I'm going to work on doing a video on that and then redo the presumptions because of my, more recent studies in the last 5 years than when I originally wrote that. So other than that, guys, I hope you comprehend what we went through tonight as far as abeyance, and what it literally means is that you haven't come forth and made the proper claim to your birthright estate, the life estate, by demanding your birthright through the merits, the spiritual credence, because your estate and your life, all glory goes to him. And again, if equity regards the beneficiary as the true owner, and a trust shall not fail for want of trustee, then who is anybody step between me and my Father which art in heaven, where I seek counsel and claim that I am his possessive and used thing? He uses me. I'm merely the pass-through for that message, that prophet, as everybody wants to claim. I'm not claiming to be a Messiah, and I'm not even really claiming to be a prophet. I don't know that I'm that good. I'm doing the best I can. All I can claim is that's my birthright. And through that birthright, not only do I have the freedom of expression to try my best to express that prophet, but I also have the right to know. So get the fuck out of my way. Excuse my language. What do you think, Danielle?
How would one go about making a proper claim?
I'm going to tell you again, this isn't legal advice. You have to unlearn everything you've learned and relearn, and part of that is concise English and learning how equity works. Hold on just a second. Be right back, folks. And again, I'm telling you, it's the public education system is an indoctrination system. And again, it too is a military setup. It's based on the Franco-Prussian military schools. Now, what I've got here, and I still have to, I gotta get some better light here somewhere. Okay. Now this is the courts and the public schools. And I'm telling you, folks, everything is trust law. I don't care what kind of contract you've got. Everything is trust law. And this book tells you right here in the language And it says, mode of attack upon title to office. And this is what we're not supposed to do. We're not supposed to attack their office or their title. It's not a matter of coming with an attack. It's a matter of coming with equity, clean hands, not to bloody a soul. Okay, it's not an act of war. No principle of equity jurisprudence seems to be more clearly settled than that courts of equity will not attempt, through the issuance of injunctions, to determine disputes with respect to title to public office. Again, it's a matter of Romans 13, 1 through 8. They already know this, operate in the same capacity, not as a threat, but as bringing peace. This is true for a number of reasons. In the first place, it is almost universally held that title to public office is not subject to collateral attack. Moreover, the public have an interest in the performance of the duties of public offices. And should courts of equity interfere by granting injunctions where the title is questioned, the public interest might suffer incalculable injury. So it's not the title or the office that you question, it's the rights to hold and enforce. Finally, from the very earliest times, the law has provided a civil remedy to determine the right to title to public office. Okay? Again, we're not going to deny the right to title to public office. That would be denying our own right to title to public office. We do have that right. We don't have to take upon it because we discern it as a privilege. But in order to do so, you have to be able to rebut it. That's those 12, rebutting the 12 presumptions of the court. Court determines everybody under administration as a contract officer. The remedy is an action of quo warranto. By what authority? So again, Romans 13, 1 through 8. There is no authority but that which is ordained by God. And that tells me that in Jeremiah 1:5, I was sanctified and ordained a prophet unto the nations. That's the error. You don't have authority because I'm the prophet unto the nations, whereas the trust that you created that I need to, what they call it earlier, revoke. I need to revoke the burial trust because I have a greater trust, and it's a life estate trust. You're planning to bury me. I'm planning to sing every day he gives me. No one knows whether I'll be singing in the future. I can only stand on that now. Eckhart Tolle, The Power of Living in the Now. This is an action brought in a court of law in the name of the state by the Attorney General or some other officer representing the state to determine directly by what right an officer is exercising the duties of an office of which he is in possession. This is because the state prosecutor, the state attorney, is the one that has all responsibility for transfer of properties, transfer of titles, rights, titles, and interests. So if somebody under him is going to be acting as an attorney somewhere to turn rights, titles, and interests over based on those endorsements, and you feel there's something wrong, it's telling you you're supposed to go to the state's attorney. That's why I go to the equity and let them know that the attorney has no authority. The attorney has to be hired by a board of directors. In that, Not only do they not have an authority, but they have no way to pose an attack against another person in that same capacity, because the person they're trying to attack doesn't have that capacity of a board of directors in order to be able to hire an attorney pursuant to being organized under the laws of the United States. Did you organize under 12 U.S.C. 614? Do you have communications, both the IRS and the Federal Reserve, as a public organization to place a public liability on a public insurance policy by making a public signature on such document, thereby amending it? If you don't have that authority, you're not supposed to be signing that shit. That's the presumption. At least not in that capacity. I will never sign anything in that capacity that the school taught me anymore. They taught you to sign a blank endorsement, meaning whoever gets that instrument now gets to take benefit. You signed a blank endorsement taking on a liability. Therefore, you're the surety. Correct it with the equity. And the access is through a court of law by correcting the record, because through a court of law, they're operating as an administration of a probate of wills of decedents. Excuse me, I'm alive. Here are the facts. Supplemental to the record. These are supposed to be in chambers, in camera. This is a private estate. You're issuing it as if though it's public, and now I understand. It is a public estate. It's the public burial trust that was established upon that certificate of live birth. There's no financial statement of intent. And it was intendment. It was an intendment. Remember in abeyance? It was an intendment. It was intended to go to me. It's being held in abeyance at the county. I get it. I'm the rightful claimant. I'm holding it. As holder in the instrument, I have the right to enforce it. Just holding it, I have the right to enforce it. But in holding it, I hold that liability to enforce it by creating the remedy for it. Ain't no other way. You have to be able to express this in those courts of law. I now hold this title in this court of law, proving Scott versus McNeil. The beneficiary has come forth and made the valid claim. He is holding the proper title. He is now holding everything in abeyance until the estate can be revoked, or the trust can be revoked, and all remainders be reverted back to him as principal, so that it can be merged in salvage, like we spoke of earlier. It's a salvation in salvage by being merged into a new name. What happens when you go through a bankruptcy? Most often it's called a corporate takeover, because it's seen that, hey, they're going towards a bankrupt status. They're in debt and they're not recovering. Let's buy them out and use their logo and brand and all this and create something new and make money on it. We have a good corporate business structure. We can do that. That's what happens. That's why we end up with 6 major corporations that are running everything else. That's why we have a UPU copyright and disclaimer that I use by adopting it and posting it on my website. That's as easy as it gets, folks. You can't deny that copyright and its disclaimer. In its very use, when you read it, it's disclaiming anything as being true. It's the ultimate copyright disclaimer, telling you get to use anything of anybody else as long as you give them credit, and let everybody know under a disclaimer that you don't know whether it's true or not. You can't validate shit. What you can validate is the legal estate is based on a presumption, and you can rebut the presumption. This is the rebutting the 12 presumptions of the court by claiming the estate. My public record isn't that presumption of public record isn't that of me. That's of an estate. The individual's name and number identify the record. I fear not, for I have been redeemed. He has called me by thy name. I am his. That's the separation for presumption of public record. Everything I do in public, he keeps record of. He'll weigh my heart when I'm done. And I don't care what kind of value system you have or what kind of weight measure system you have. I'm sure he doesn't use that same measure system. I'm told, or I believe through the scriptures. However you want to put it, I can't say that's true. You know what I mean? I know it seems like a lot, brother, and it really is. But I hope you get it soon because I know what you're going through. I really do. Like I said, I wasn't a fun one to be in those courts. I was cussing and screaming and kicking and hollering all the time. If you think I only did it that one time 7 years ago, you're wrong. There was a time I did sit there and just listen. But then I started speaking up, and then I just started signing everything UCC 1-308 and didn't show up for court. Then they dragged me into the court, so they got the same thing I used to do. I've got to learn to change, so that's what I've been working on. That's the only way I see remedy in my case, and that's what I'm going forth with. And again, folks, that estate recovery is held through the Health and Human Services. Every state is required to have an estate recovery program, and it's administered through the Health and Human Services. Again, that's where they establish the state's vital statistics jurisdiction. It goes through Health and Human Services first. Through Health and Human Services, it hits Social Security, DMV, voter registration, and public education and things like that. You look at that chart and you see where it all goes. You'll see how it flows in and out and who's creating the monetary value and where it's established at. That county registrar gets a birth certificate on all those transactions, and it validates that certificate of live birth. Then somebody makes a financial statement of intent based on it, saying that we have access to the estate to place a liability on the record against the general ledger because somebody made a claim that that's an official title. Somebody's holding office. It's sickening. That's a spell of illness when you're born. 42 U.S.C. 1395X. Greetings, Janine. Janine Matos. I want to take a moment to greet everybody. Crazy Horse Lady, Janine, Disciple of the Messiah, Unslaved Truth, Aaron, Norman Longstaff, Russell Unleashed, Thunder Chicken Swim, Sam Gold, Mark Jones. Greetings, everybody. Kevin K, Dean Phillips. Don't know who all's here, but Bleak Narratives, Producer Moose, Red 40, Kick Out the Repairman, R Pole, good to see you, Damsel Medic. Appreciate everybody's support. And unless you've got anything else, Danielle, I plan on go ahead and closing out. I hope this is a good one. Greetings, Laura, down there too. Thank you for your support. And again, one of the most important things in all of this, guys, is patience. And like Paul says, remain in your element even if they do lock you up. All right, Wobbly Boost. Scream and holler all you want. Thank you, brother. I appreciate your support too. But Iman Bay as well. So I'll keep you in my prayers. I will ask God to bless you tomorrow with the right words, that he flows through you in full support, footprints in the sand style. Not that he makes it easy on you, brother. He's not going to carry you all the time, but maybe he can kind of help lighten the load and inspire you somehow tonight.
Thank you.
All right. And with that, folks, we're out of here. You know, I love you, but I don't give a rat's ass whether you love me back. So may God bless you and have a good night. Bye now.